Morning, everybody. Welcome to the December 13th meeting of the CBLS. Officially call this meeting to order, and with that, we'll have Adrian call roll. Acosta?
Here.
Hammerschmidt? Hershenson?
Here.
Lester?
Here.
Levy?
Here.
Torre? Here. And Vance?
Here.
We have it. All right. There we go. And with that, we'll now turn to public comment. If there are any members of the public that wish to comment, I don't see any here, and I don't believe there's anybody queued up remotely. So with that, okay, well, we're now past public comment. Okay. And now we'll turn to the staff reports, and Amy is going to be having some staffing updates for us.
All right. Good morning, everyone. We have a couple of updates about 2 open positions that we have in our legal specialization team here at the State Bar. The first is we have a program position that was vacated a couple of months ago. So we will be launching a recruitment effort for that. And I think we mentioned this at the last meeting, but one of our program specialists, Elizabeth Moe, has moved on to another position within admissions. She will be working on our testing accommodation program. And so with that, we have 2 openings. And again, our recruitment effort for that starts in January of this year. So more to come on that. And we also have the staff here because we are going to be conducting a new member orientation. So that's what I have so far for staffing updates. The next item is that orientation. But any questions, sorry, before we move to the staffing updates, from the staffing updates? Okay, here we go then. All right, so we want to provide an overview for our new members. We have 3 new members on board, 2 of which are here today, or 3. Yeah, all 3 of you are here. Jeffrey is, yes, so we have 4 new members, 3 are here with us today. And I'm assuming that each of you participated in the training that happened in early October 4th in Los Angeles. An orientation that was an overview for a lot of sub-entity members. So there was other, like COAF, I think, was there, perhaps, or CBE members. So everybody was invited to attend that. And that gave you a global understanding of for example, our Bagley-Keene process, our invoicing process, and so on. So more logistics and orientation to the State Bar. This is an orientation on the programmatic perspective of legal specialization. So we're going to do an overview, a little bit on the rules, on the program oversight, like your role and staff roles, and where we cross paths in our roles as well. So with that, Adrian, do you want to start the PowerPoint? And anytime, please feel free to ask questions if throughout this process. So to start, the entity that oversees the work of the CBLS is the Board of Trustees. It's comprised of 13 members, and rules, guidelines that we develop here go and are approved by the Board of Trustees. All right. Next one. So these are our rules, and I think Adrian has a set of rules for each of you. They were recently revised in this year, in 2019. So these are each of the areas. So you'll be getting a copy of them. The rules are spelled out as follows. So the Rule 3.9 describes the composition of the CBLS. Again, I mentioned that they have been revised, and this is as a result of what we've been calling the Appendix I recommendation, but it's a board directive to address and find a remedy for some of the issues that were raised during this overview. The next is
Amy?
yes.
If I can ask a question.
Sure.
Last year, proposal with respect to undivided loyalty to the state bar?
Yes.
Is that still here?
No, it's not. Actually, that's a third rule that's listed here. So there was an effort to create one conflict of interest rule for all sub-entities, and that did not progress. We received a lot of feedback around that. And so right now, our original conflict of interest policy exists in the rules under 3.95 as they did prior to that. So that did not move forward. It did not advance. And so 3.95 is our conflict of interest policy. I think some of you got to see this during the orientation. 3.96 is confidentiality, and it's really the manner in which confidential information stemming from this meeting should be handled outside of this meeting. 3.110 are requirements for certified specialists. The next are logistic areas that programmatic, requirements such as fees, application for certification, and reporting requirements. Those are critical to understand because you will be serving as the appeals body. And so when there are issues that for example, if somebody even has a waiver asking for an exemption and you need to know, it could be related to fees, these are the areas that you would go back to. So like Rule 3.111 is the fees rule. You want to go to the next slide? And then education requirements for specialists. We often, I wouldn't say often, but thank you. We have received requests or petitions and waivers for considerations related to education requirements. Next is practice and task requirements. That's Rule 3.115. 3.116 are the rules related to the examinations. References. You'll hear later, is one of the areas that is a consideration when it comes to the application process itself. 3.118 is one that impacts you. These are the waivers and modifications. So when there is a request to waive any part of these rules, those are spelled out in that rule. The recertification process is incorporated in Rule 3.119, as well as the denial, so that people know what the process is when an application has been denied, whether certification or recertification. The next rule, 3.121, describes what the State Bar actions that can be taken on some of these applications. One of the
Are we going to get into later on what happens on the approvals and the recertifications and who's doing those? Because I understand they're not coming up to us anymore. We're only handling the approvals.
Yes, we're about to describe that as part of the orientation. One of the forums that exist for applicants who want to appeal a denial is an informal conference. So 3.122 describes that process. It's the informal conference requests. 3.123 describes the denied applicant and what the state board actions to that denial what they involve. 3.124 describes conditions for suspension and revocation of certification. 125 describes the appeal of that denial, suspension, or revocation. And lastly, 3.126 designates the State Bar as the certifier for the entity that certifies a specialty area. So that's a quick kind of reference list, but each of you have a copy of the actual rules, and they are not that extensive. All right, so then I talked about the fact that we want to describe role functions. So the role for the committee, or the group here, so this is for the California Board of Legal Specialization. Mark has brought this up, that you will be serving as the appellate body for certification and recertification applications. So last year, let's say in 2018, the process was that we used an advisory commission. Advisory commission members or commissioners were the first body that received the applications to review and determine which ones advanced forward. With the new changes and board directives, the commissioners and the advisory commissions altogether sunsetted. And so that determination and that role of was transferred over to staff. So staff does the initial review of certifications and recertifications, and we also, when there is an appeal, like somebody is appealing any of the decisions, that will come to this group here, and that's what that refers to. One of the requests we've received from the CBLS is that we preserve some kind of expertise when it comes to reviewing the applications. So you'll hear about this later, but we've been able to characterize and categorize some of these applications to ensure that anything that needs to get reviewed, and we've talked about what those conditions are, and you'll hear about it later, that we use a working group to make that determination, to help staff guide us through that process. And so we're planning on doing that. And again, it's to preserve the expertise that advisory commission used to lend itself in this review process. This group is also serves as a policy-making body. Later on, we're going to talk about guidelines when we review new specialty areas, and that should be developed by this group here as to what criteria we want to apply when looking at new specialty areas. But that's just an example of the types of policymaking that you will be involved in. The other is the establishing, approving, denying requests that come in for new specialization areas. We have one on the agenda that has been ongoing. We've discussed it previously, and we have more to discuss today, but that is one of the roles of the CBLS. The review of overall program health. You will see a report that we add on every agenda related to program health, where we look at the financial standing, the number of applications, as well as the applications that are not renewed from one year to the next, and also at the continuing education requirements that have been the compliance rate for each of those. And that's just a way of looking at program health. The other is approving or denying specialization in light of MCLE or non-payment. Again, one of the reports that comes up is people who have not met their obligation, whether it's education or payment, and this is a group that looks at any request or the overall set of recommendations.
I just had one question about
Sure.
that. Because we've had this situation several times where we have like the list of people that haven't paid or that haven't certified. If maybe in the future there would be some move to basically having somebody's certification just revoked or basically expiring in the absence of that, in the absence of fulfilling those requirements, as opposed to when they don't meet those requirements, the list comes to us, and then we're like, oh, okay, give them a few more months or something along those lines. I mean, has there been any thought to that or to maybe going that direction? I mean, I don't think it's that big a deal, frankly, if we just review. It's like, hey, here are the people that haven't paid or haven't done their MCLE. Like, we just send them like a letter or a notice saying, hey, get your act together or you're going to get it revoked. But I personally, I don't know what everybody else feels like. I think that if you don't meet those requirements within some reasonable period of time of the deadline, your specialization should essentially be revoked. Mm-hmm. And then you can maybe ask after that to be reinstated, but the burden shouldn't be on us to revoke their certification based on them not doing something that they should have done in the first place.
Well, I think one thing is that we're complying with the rule here, and let me go back to look at, I think when you look at the rules on suspension and revocation, it's carried out by this group, so we have to bring it to this group altogether, right? So the question is, do you want to do it in anticipation of somebody's revocation, or do you want to do it in after, right? That's really what you're getting at, Roy.
Right, yes.
And so, I think traditionally we've done it in this format in the event that there are some exceptions. Like if the rate is high on the non-compliance, for example, we've done this through actions carried out by this group here, by CBLS, when we've extended the compliance for education because we've had a high rate of people who have not met the educational obligation. So, it's really up to the group how you would like to carry that out, because we have made exceptions as global exceptions, not individual where we've extended the educational, the time to meet the educational requirements.
Could we theoretically, as a group, I'm assuming the answer is yes, could we, when we're presented with a list of folks that haven't sent in their, either sent in their payments or haven't complied with their MCLE, could we as a group say, okay, look, we are giving, this board is acting that, everybody on this list is given until X date to fulfill this requirement, and if they do not, as of that date, their certification would be revoked?
Yeah, I think we do that. I mean, if you look at that item, hopefully this is not me. Is it? Oh, no. Okay. I am so sorry. I'm doing this on camera as well. Sorry about that.
It's happened to everybody in this.
All the rest of us just looked to make sure ours was silent.
They're for the grace of God, right?
And I'm usually gawking at that, so my apologies. I really am so sorry. But I think we do that, though, Roy. And so can you explain that process for us? Because I think you keep it as a standing agenda item.
So whenever we do have revocation items, we do provide a consent list, and then the recommendation is always, if there's no response to a final communication within 30 days, that the revocation will be final.
So okay.
So we provide time.
Yeah, that's perfect.
Okay, great. All right. So the next items then, serve as an appeal body for all determinations. So as I mentioned, there's in the rules, you've seen that there's an ability for people to submit requests to waive certain parts of the rules. When that comes in, and a determination is made, the appeals come to this group here. And a very important function that we rely on the CBLS is outreach for legal specialization. This is a shared task, but part of the effort that we would like from this group is support in doing outreach. We go to various conferences to put the word out there about legal specialization, the benefits of the program. And so for future events, and we're going to have a few listed here, we'd like to invite any of you to participate with us and co-present or be available. And then also in your own daily interactions, whether it's with bar associations or organizations, just letting people know about the work and the benefits and merits of legal specialization in general in California. All right. So now on to staff roles. So the three main items are related to initial certification and recertification. And one of our staff here, Janelle, will be presenting on that process. So let me move on to her slide.
Good morning, everyone. I am here to discuss the file review for the Legal Specialization Department. So applications are given to us by paper or through AIMS. We are to review them and make sure they are fully complete, which means that the requirements met need to be the area of practice are for 5 years. They meet all their cases and trials, education, and references. If that is all met, that is a complete one, and it is then moved forward for staff to go ahead and...
Can I ask a question about the references piece?
Yes.
How does staff review those references that come in? Because from the commission standpoint, we had some experience with some of the practitioners that would provide references. How does staff have, what are the criteria that you guys look at?
It's the same as they were before. Adrian?
I don't know the specific number, so we asked the applicants there to submit the names of references that they have worked with, that they have opposed, judges that are familiar with their practice, and I believe there's one other one. I'd have to pull it up, but I'll make a note to provide it to you. But we do ask that they provide references in each of those areas.
Well, for instance, because, from the commission standpoint, we had some historical information about the references that would come in. How do you get to incorporate that, or are we just going to lose that historical understanding of who these references are, where they come from, and whether or not they're actually knowledgeably
Yeah,
voting for those folks.
I think the question, at least in my interpretation of the question, is less about the quantity and the quality of the reference, right? And the advisory commissions, there was familiarity with people in the area of practice. And so how are you vetting the quality of the reference, not the number that come in? Is that, Mark?
Exactly.
So I guess previously, the advisory commissioners would be able to review that reference and make that determination, looking at quantity and quality. We are looking at pretty much the rating itself, right? I mean, we're making that determination that we receive a specific amount of positive determinations. Anything that sounds neutral, we're setting aside, and those are the next category that we're going to describe here when we talk about completes, 2s, and 3s. And so what we want to do, and what we're aspiring to do, and you'll hear a little bit about our challenge with this, is to create this working group that will be able to do that. The problem is we still, and I think fundamentally this problem existed even when we had the advisory commissioners, is that previously we had 10 advisory commissioners. We have applications from 58 separate counties in California. There's a chance that we might lose out on some of that quality determination because some of us are unfamiliar with the landscape from one county to another county. And so we're fundamentally stuck in that same scenario now. So the idea is when anything either looks neutral to us, we set that aside to try to work with a working group. Our hope is that that working group provides the specialist, the legal expertise to determine, to make a better determination or quality judgment about that reference. And so that is what we're attempting to do.
So just as a follow-up, because I just wanted to look at, so the rule, an applicant must provide references from attorneys or judges whom the applicant has identified as familiar with the proficiency. I don't have to read the whole thing, but are you then vetting, I'm not an attorney, but say I'm an attorney, right? Are you guys then going and checking the status with the state bar of the people making the reference? Like how are you, but that I guess is the question is how are you ensuring that that's a legitimate person making the reference?
So now with this AIMS system, AIMS pretty much has every California licensee's information. So when an applicant submits their reference, all they're submitting to us is their bar number. And then what the system does is it pulls up their bar number and then it pulls up their licensee information and then it sends the questionnaire directly to that person.
So, I mean, and I think to get at what both Rob and Mark are, I think, getting to is that if we have somebody that theoretically meets all the all the requirements, like just checks all the boxes, and has 3 references that just say, yes, I'm fine with this person, without much more vetting of that, like they are going to be approved by staff for certification, I would imagine. Right? If there's 3 positive references, and all we know is that they are members in good standing of the bar. That's the only thing we know about them. And they say, yeah, this person's fine. And the person meets all the other requirements, then the application is essentially going to be certified, I would imagine.
It's checking the box. As long as there's 3 in that are positive, it's a box is checked and it moves on.
Right. Okay. And the other thing I would just add, just as a rule of thumb, if an applicant offers up a reference, and that reference is either neutral or negative, I think that is a massive red flag.
So that is our complete 2s and 3s.
Yeah, that's the next.
Complete 2s are when we receive the independent inquiry. They are stating that they do not know the applicant that are greater than recommended. Or they submit supplemental information to satisfy their T&E. So, for instance, if we have three positives and maybe a do not know, we go ahead and mark that as a complete 2, which will then move to the working group members to go ahead and look at. Or the complete 3s are complete, do not recommend, regardless of their task and experience. So we definitely push those through to the working group, and they go ahead and look those over to give us a recommendation on what we should do further from there. And then if there's any others, the CBLS will then conduct appeals if needed for those applications.
I have a question.
Go ahead.
On the cases and trials or requirements, previously if, for instance, the number of trials weren't met, there was an explanation of, similar type of work that was being done by, or experience by the attorney. So who's reviewing that and how is that looked at? Because in the Commission for Workers' Comp, there were some explanations sometimes that looked good, but if you really knew the practice, it really wasn't fulfilled in terms of a replacement for maybe the trials that requirement that were requested.
So those are the complete twos, which are then set aside and asked for a working group member to go ahead and look at further.
But how do you as staff know the difference between the two? Something sounds great, but because you practice in the area, you know that they've got 23 of these minor hearings, which are a nothing, and nowhere near equivalent to trials, but they've glorified it. How can you tell the difference at staff level?
So we're not advancing those based on staff determinations. So anytime there's a substitute, for example, between the cases and trials requirements, and somebody wants to either substitute one for the other, that gets flagged and categorized in this item that we call complete twos or complete threes. So staff are not making that determination. We're bringing that to a working group. So, Norma, to answer your question, it's done like we've done before. So, for example, in workers' comp, if somebody wants to substitute some trial time or explain, why some of that has not been met, that will go automatically to a working group member in workers' comp.
So this, I think we need a little bit more explanation about who the working group is comprised of.
Yes. So and this was going to come up at some point, but we could jump into that now because I think it is the next slide.
So right now we have recruitment for our alleged members who are Chris Frick and Dennis Mayo. Their working group members we're still recruiting for those, so it's an ongoing process. We went back from 10 years and asked people to be a part of that. So again, that's ongoing. We have definitely recruited for our graders. We are in the process of grading right now. And then as well as our exam developers, we will start recruiting that once we release our 2019 results.
Yes. So Natalie, to go back to your question, so these are the different types of recruitment that staff have been involved in. These represent also tasks that were carried out by the advisory commissioners. And so what we're doing, for example, is for the working group, CBLS here directed us to try to establish working groups in each of the specialty areas of up to 5 members so that staff can consult whether it's on applications, even reviewing the exam questions as they have done in the past. One of the challenges that we've been presented with is the fact that because we don't have active activity happening from one quarter to the next, keeping a working group interested and engaged has been challenging. So we've reached out, for example, we have some working group members I'm trying to think, like, let's say it's in workers' comp. I think that's one of our bigger ones, or estate planning. It's been hard to get up to 5 and to keep them involved. Sometimes they are reviewing 10 applications, and that's all the activity that we have. So, but that's what we've been doing is we've really reached out to previous advisory commissioners, as Janelle has described, and we've gone back up to 10 years. So what we have is advisory commissioner members that have experience, and that's really who our working group has been. In terms of our engagement, that's been limited, and we're trying to develop a more consistent plan. So, for example, like if meeting every other month, doing a call, we don't have enough work for us to meet in person. So we've sent out applications for them to review questions about anything that's come up that we needed some guidance on, as trying to use them as much as we have in the past with advisory commissioners. Yeah. Sure.
Do we have a backup plan if we don't get enough volunteers for the working groups?
We plan on recruiting constantly. So replenishing anybody who drops out, and that has proven successful. I mean, if you consider that the advisory commissioners sunsetted in May, we've had things come up. For example, we wanted them to also review the examinations before they were finalized. We've reached out to them to help with either identify graders or serve as graders and move from the working group as graders. Also with some applications already. And so we haven't had an instance where we couldn't find anybody. The only issue is getting up to 5 has been a challenge to us. So our backup is, that we're going to have variation in the number of members, but we are not going to make determinations on certification or recertification applications without conferring with an expert.
And now, are there applications that never go to the working group, that they've checked all the boxes and so they're just approved without any oversight from a working group?
Yes, there are.
And if you can remind me, LEDG stands for what?
The Legal Specialization Examination Development and Grading Team. Yes. Traditionally, people have talked about EDGE, and you hear that for the bar exam. That's the exam development and grading team. We added LEDGE. There was going to be a silent S there, but it didn't make sense for a legal specialization, education development. But anyhow, the point is that what we're doing is replicating what we've done in the past. So Dennis and Chris have served previously as, I think before we used to call them consultants, and they consulted on the grading process and were experts on the grading procedures altogether. They're serving that function now, but under this new directive, LEDGE team members, graders, and exam developers are paid positions. We are replicating the same efforts that we put forth on the bar exam with the legal specialization exams, and that's why the model looks the way it does. This year, we also have an analysis that's being conducted on the grading. And so our grading process is a little more complex this year than it has been in the past. We are looking at whether being a specialist is impacting the grading altogether. So we're having specialists and non-specialists, so attorneys that perhaps are not specialized in that area, grade the same questions to determine whether there's any variance between that. Any variance between a grade that a generalist provides and a specialist provides. In the long run, only the specialist grade will count, so to continue on how we've been grading in the past. But I think what we're trying to find out is whether it's a requirement. Because unlike the bar exam, which relies on holistic grading, this relies on grading rubrics. And so there's a potential that being a generalist could be sufficient to the grading process itself. Again, we're not going to deviate from previous practice, and only a specialist grade will count, but it is an analysis that we're conducting internally.
Have we formalized what the relationship, I mean, since we're at such an early stage, even with the working groups, and there are several working groups that don't have enough members, if any members, have we formalized, or at least do we have an idea of what the interaction is going to be between exam development and the working group?
Yes, that's a great question, because I've talked about the fact that we've been very pressed to find people for both grading and for the working groups. These are the most active groups that we have at the moment. And so the question has been, if you're in the working group, can you grade? And then if you're grading, can you become an exam developer? What are the interactions between each of these groups? And Adrian, you're going to have to correct me if I misstate this, because I often do doing this without my notes. But if you're a working group member, again, the things that we've been bringing forward to the working group is the certification, recertification applications. We wanted them to also review all of the final examinations for comprehension and so on. And as a result of that, anybody who's, like, for example, developed the exam cannot grade the exam, right? Because there could be a potential bias presented in that process. So if we have an exam developer that went out to the working group, they wouldn't be able to review they could review the entire examination, but they could not become a grader. So because we've been pretty much saturating the same group of people for the past 10 years to participate in any of these, we've had to be very careful that exam developers do not become graders. But if you're in the working group and you'd like to eventually become a grader, you just would not have been able to review the entire application. So this has been.
We sort of solved that on the commission, is you just didn't grade your own question. And so you sometimes had your questions there, sometimes you didn't. If your question was there, you just weren't a grader for that. You graded some other question that was being asked, but you were there for historical in case, well, where is it that you were, ideally trying to come from? How do we need to, so
Yeah,
why
and
can't we do
we'll probably follow that same protocol. We've just been a little bit more careful and walled people off a little further, and which is, I think, one of our challenges with getting enough working group members. However, what we tried to do is ensure that those policy considerations were maintained. So that distinction between somebody who developed the question does not become a grader, and then for working group members, again, we've been using a lot of previous advisory commissioners, and as a result, also some of our graders are people who've recently become specialized as well. Yes, thank you. So yeah, that's all the role distinction between that working group, graders, and exam developers. And I hope I didn't confuse everybody. We could definitely spell this out a little better for a future meeting.
I mean, it's just. I mean, a lot of us that are very familiar with the commission process and stuff like it was a one-stop shop for everything, and I mean, it was always nice to have kind of a clearinghouse of different eyes that saw something. That's going to be a little more difficult with this setup. Not impossible, but that's. I mean, I think that's where the concerns are coming from.
Yes. Well, and we know that the tasks for a working group might morph. I mean, we might identify something here at some point during the year that needs to get addressed, and perhaps a working group is the best group to do that. And so we're open to those recommendations. What we're trying to do is ensure that the quality is consistent for legal specialization and for the practice. And so, we're definitely open to that, just FYI. Okay. So let me go back to this item. So we talked about the recruiting, and then the area where there's overlap is outreach for legal specialization. If you look at upcoming events, I just wanted to bring these up to you. So we talked about the fact that we've already had one grading session. We have 2 more scheduled, January 11th in San Francisco and then January 18th in Los Angeles. We also have the CAAG conference, the California Applicants Attorneys Association, the 2020 Winter Conference. That's happening January 23rd through the 26th in Palm Springs. Again, this is one of those events that if you're interested in helping, we have a table out. If people have questions, you would be available as members of the committee, and we are going to be there. You're welcome to come and join us. And then also our next CBLS meeting is March 13th. But in terms of outreach, a joint effort is really what we want to do. Were you going to say something, Mark?
Yeah. California Applicants Attorneys Association.
Yeah, what is that?
Who is that? What is that?
Oh.
That's what we're working on. Oh, working on that. Okay, thanks. See? I have no idea. Don't know the lingo.
Okay. All right. So any questions about the orientation? And I mentioned this. We're 100% available. If anything comes up, you have questions in the future, maybe it doesn't hit you now, hits you later, please don't hesitate to contact us. Let me also introduce you to the staff. Everybody at this point probably is familiar with Adrienne Galan, right? Janelle Dela Cruz is one of our program specialists. She's been on at least 2 years, right, on legal specialization. And then our recent addition, Wes Galan, he is coming from the call center, and he's joined us probably, he's been on for about 3 months, right? Mm-hmm. So that is our team. And again, we have 2 vacant positions that are going to be filled in the near future. So, and then everybody should have my email address. All right. Thank you.
Thank you, Amy. And With that, we would turn right back to Amy, I believe, for recent developments, and in particular, I think we're going to be talking a little bit about Ames.
Yes. So just wanted to give everybody a quick update and maybe bring everybody to speed on this. So we implemented a new case management system, the Admissions Information Management System, back in March of 2019. We launched. We had about a full year of development. Legal specialization was one of the functions that was developed into the system itself. This year, since we've launched in March, we've hit a few obstacles and challenges in using the system. We found certain functionality that did not work as planned. We've found some new areas that we need enhancements in. As a result, we went to the board, requested to apply admissions funds for addressing some of these. And so we are in the process right now. We've recontracted with our original vendor, Slalom, and we are in a version 2 development right now. And we're looking at things that were both in our backlog using our JIRA system. It's a software that keeps track of needs within the system itself. So anything that wasn't addressed previously in our first phase of development, as well as new issues that have come up, are categorized and documented in there. And so we came up with a list of about 34 priorities that need to get addressed in this next remediation stage, so our phase 2.
Can I ask a question on that process?
Sure.
We had the benefit of having Cynthia Levin here on the board for a number of years. Is she still helping us out in this process and trying to help remediate the problems?
No, I mean, she's termed off, and so, yeah, she's not participated in this.
Okay. Without her being as part of the board, is there a way to, her expertise was pretty phenomenal.
Oh, yeah.
So.
Yeah, I mean, let me just say a couple of things that have changed. I mean, Cynthia definitely contributed and helped us, especially when it came to looking at the phases related to QA, that quality assurance testing, as well as our UAT, user acceptance testing, and helping us distinguish what we need to, the differences between those two testing areas. One of the things that we've done differently that we've applied for this next phase 2, based on lessons learned from phase 1, is that we have now somebody that we didn't have before that is dedicated to the testing itself. So it's like a coordinator, but looking at both how we interact with the IT and operations. We didn't have this before, and that's where Cynthia was kind of an interpreter for us. Like, we brought her some questions. But in terms of like having somebody hands-on and doing that, that position has been filled. We didn't have it before, as I mentioned. The other thing that we're doing is we're having more guided sessions when it comes to our UAT. Before, we had a lot of independent. We would get the login and we'd have to sit independently and report back to our vendor. We are now working with guided UAT efforts, and so that is making a world of difference in terms of
and I don't know the lingo. UAT is what?
User acceptance testing. It's one of the final stages before we go into production. So this happens after we do QA testing, which is quality assurance testing. And that's more technical. And then the programmatic testing happens in UAT.
Right. And I have a familiarity and experience in application development and whatnot. So not clearly to the level that Cynthia had, but I'm more than happy to answer questions. I don't have that level of expertise, but I've been there.
Okay.
I know the lingo.
Okay,
And
great.
I've been that interpreter between IT and the business side before.
Okay, so if I get anything wrong, you can help too.
Yeah, you're good. You're good. Yeah, it's the last phase in the development cycle, right? When basically you say, yeah, this does what we want it to do, go. And then it gets pushed into production and you're done.
Well, and I think they're all good questions, because I think that, one of the natural questions is like, oh, how did we get here? Like, is a phase 2 needed? But a phase 2, a phase 3 is always needed for a lot of technical initiatives. I mean, a lot of organizations actually save money from 1 year or allocate funds to enhancements because they're going to come up. We're always trying to, systems improvement is a natural part of any technology development.
And I'm familiar with Jira, and I've operated in the Scrum and an Agile, so I can help
Yes.
you with
And
navigating that.
Yes, great. So what does that mean for legal specialization? There are two areas that legal specialization has been pretty successful in terms of the information management system. So as I mentioned that there was some setbacks. The setbacks did not happen in legal specialization. They happened on the admission side because this system, again, carries out multiple functions from the moral character determinations to pro hoc vice applications, law student applications, and then legal specialization. So legal specialization had only two setbacks, and they were very small. One is the fees, like the interface for fees, ensuring that information that we pay, that fees get paid on our end goes back to member services, as well as compliance. And that interface is being addressed in this phase 2. And I think it's already been fixed, hasn't it, Adrian?
It's close.
Yeah, okay, so we're very close to that. So again, most of the issues were related to admissions, and the funding that was required for phase 2, we did not touch any funds from legal specialization. They were all pulled from admissions funds. So again, we're going to be done, I think, with the last builds or sprints as of March 2nd. And so from March 2nd through March 23rd, we'll be in support. Our vendor will be in support mode. All right. So with that, are there any other questions? Okay.
Sounds good.
All right. Thank you.
All right. Thank you, Amy. And now we'll turn to the consent portion of the open session. And that has one item that has the approving the September 6th open meeting minutes. And just for this, just as a reminder for our new members, would not be voting on approving those minutes because you weren't here. So if
I'll make the motion to approve the minutes of the
Okay.
group.
Do I have a second?
Just take it a quick peek.
I'll second.
Yeah.
So as anybody opposed to accepting the open session minutes from September 6th?
No,
No? All right.
I think that's it. It's the 3.
Yeah, that's it. I think the three of us are fine with those, so those are approved unanimously. All right. Now we'll turn to the business portion of the open meeting, and with that, we will turn to the financial and operational key indicators, and for that, we go to Amy.
Okay. All right. So I mentioned this earlier, but this is a standing item that's on the agenda. It's each CBLS agenda. And this is a report on financial and operational key indicators. The first is the budget. I think at our last meeting, we did not have quarter 2 completed. We now have up to quarter 3, and so that has been attached in terms of our financial standing through the board report. As you will see here too, the revenue's up 3% compared to last year overall. Just if the effort is to look at program overall health, I think that is a conclusion that needs to be highlighted. Part of that report also includes a total number of specialists. And as you can see here, compared to a year ago, within that report, we are there's a slight increase of 60 specialists. And there are only 2 areas that saw a decrease, and that is criminal and tax. And again, they're very small decreases. I think there was a total of 6 for both categories. The report also looks at resignations. And it's a lot of material to go through, but the last 3 pages, I think, summarize these. So resignations were pretty consistent with the previous year. So in 2018, we had 131. I'm sorry, this year we have 131, and in 2018 we had 161. The report also includes the numbers for 2017. If you look at a majority of resignations for 2019 are due to retirement, so all happening for good reasons. And we also expect to see resignations going up this month for the legal specialization annual fees. So the last part of that report looks at education compliance. So the current analysis is being conducted with Group 3. Their compliance reporting period opened last week. There are about 1,972 specialists in that group, in Group 3. And so the first group, this is going to be the first group that's going to be able to report their compliance using our new AIM system. And so these are our indicators. Are there any questions? Oh,
Yeah. With respect to the statement of assets, liabilities, and net position, do I understand this report to show, as of September 30, legal specialization has a net position of $4,791,000 as a separate part of the State Bar?
Yes.
Okay.
Those
And then
funds are separated.
within this interfund receivable, what is the interfund receivable? Where's our loan?
Yes, so that would show up on our statement, and I could provide those at the next round. So when we initiated the AIM system, the Office of Admissions borrowed $1 million from a legal specialization with the promise of paying $100,000 a year. We are in year 2 of making that payment. It's been incorporated in our forecasting for 2020. So on a yearly basis, we will be paying legal specialization $100,000. And so, yeah, I could provide our reporting on admissions to demonstrate that payment has been made and has been built into our funding for 2020 as a payback.
And so is that the last page of, I think, attachment A? I'm just looking at the interfund. Like that's showing 4.791 million under legal specialization. So is that?
Interfund is 2 things. One is payments, outgoing payments.
Okay.
So it's pretty much like the overhead from each group. So admissions has an interfund, legal specialization. Every department in the State Bar has that.
Okay.
There is another interfund allocation that happens, which is $100,000 that gets incorporated back to you. So it's how each of the units at the State Bar process funds from one unit to the next.
Okay.
So you'll have ingoing and outgoing this year for legal specialization.
Okay. And going for, I'm actually trying to match up where, because the attachments don't have the same page numbers as like the one that we had on
Yes.
email. So I took a little.
So if I could highlight then each of the items I highlighted for you. If you look at attachment A and you go to page, let me find it on the attachment. If you're trying to look at that.
That interfund, that was, I think, the last page of attachment A.
Well, if you look at attachment 1 in that, of course it doesn't have a page, but attachment 1, legal specialization is in here, and it'll describe our current funds, actual funds compared to last year with the variance, and that's how I got to what our revenue looked like this year. The other item that I highlighted, is that's what I highlighted from the financial report, just to get to a summary of financial standing. Attachment C is our applications, and when you look at it's not attachment C. Yes, it is. So if you look at attachment, let's start with B. So it looks like I printed the colored copy. It has the specialty areas, and as of December, what 2019 looked like compared to a year ago, And that's how I got to our total number of counts of where we're at with the number of specialists by area. And that's where the determination that criminal and tax were the only ones that had decreases. The next page has our standing in terms of the number of resignations and by area. And they're color-coded so that the lightest blue pertains to 2017, medium is 2018, and then the darker blue represents 2019. And then the one page after that is the education compliance. There's a lot in this report. As you can see, one of the requests that we received is to get and Mark, I don't remember if it was, you called it like a operating statement. And
Balance sheet is what I was.
balance sheet. And so that's why we've attached the board, because the board prepares a balance sheet, and which is why that document is so lengthy. You're getting information about overall state budget information, state bar budget information. So that part has a lot extensive information.
And I just had one question, and I for the life of me, I can't find it in the packet. It's probably just somewhere else, different from what we had seen on email. Like just in terms of just kind of almost longitudinally, like the revenue for the program versus our outgoing expenses. Like what is that kind of looking like? Like not just year over year, but like as a trend. Because I'd seen something. It was. I had marked it down as attachment. It was attachment 2, page 1 in what we had reviewed on email, but I don't know where it is here. That it seemed that our revenue was outpacing, was healthily outpacing what our operational costs were, and I just wanted to know if that's something that we're anticipating for the future, because that may be something in terms of like maybe modifying fees or looking at some of these different, or maybe looking at what the program's doing maybe in terms of outreach or that sort of things that may actually take advantage of some of that revenue.
Yes, and you're right, because some of that could have policy implications.
Right.
I know in previous years before I joined legal specialization, there was a policy determination made, like, for example, I think one year when we had a lot of people take the exam, fees had been waived or something like
Right.
that. And so you're absolutely right that the revenue is outpacing our expenditures. One factor that contributes to that is we have not bought our item banking solution. We know that's going to have a heavy price tag. We did not think that it was a timely decision right now, given that we wanted to ensure that our information management system stabilized before we ventured into a new technical initiative. So this year we had allocated some funding for that tool. And since that's a part of why there's been our revenue has been higher than our expenditures. So this is something that we're going to carry up to next year. So we don't anticipate that proportion of staying the way it is right now.
Okay, and I just want to, I mean, just in case there's any kind of confusion, I am 100% fine with that. There's been so many changes, just both to the structure and to how the exams are going to be created and banked, and like some of these new kind of technology solutions that we're going to have, that we don't really have a lot of cost certainty going forward. But just saying, and obviously you already have your eyes on this. Just going forward, it's one thing that I would definitely be interested in is over the next, once we actually figure these things out, like if we can get into like a basically cruising altitude where like we have some kind of cost certainty going forward over the next 2 years, 3 years, 5 years, to like that there would be like a calibration of the incoming revenues, like vis-a-vis fees and all that.
Exactly, because we also remember we have a reserve limit as well, so that that's something that we should probably have. That needs to get factored in and how the determination on how budget expenditures happen. One quick thing is that aside from that, oh my gosh, boy, I totally lost my train of thought. But again, I understand that your request is to look at the budget implications to see if there's any policy considerations that stem from that.
Right. I mean, I think it's very preliminary because I wouldn't, I'd be the first one to say that I don't think we should do anything particularly rash or too quick before we know what our expense kind of like outlook is going to look like in the future. But it kind of jumped out at me that like it's outpacing now. Like we're kind of essentially having like a rainy day fund to be able to pay for some of this stuff. Some of these information solutions and some of these like new processes that we're doing. But
Exactly.
But we need to keep our eye on that.
Yeah, we will. And the comparison from one year to the next is also challenging, and it's challenged by the fact that obviously you've seen here that we've had some staff salary savings. It's been challenging to meet our staffing requirements internally. The other thing is that we also have transitioned from this advisory working group to advisory commissioners to paid positions. And we also hit on an exam year, but we have an exam year coupled with also a grading year. And so there will be some variance. I mean, in terms of reaching like this cruising altitude or stability in our budgeting, it's going to be hard because I think it varies so much on years that we have the exam and years that we don't. However, an item banking solution will help us create more consistency because we could develop questions throughout the year, even on a non-exam year, because that'll make our exam year easier and our budgeting and budget spending more consistent from one year to the next.
Right, but the development of the exams was always a 2-year process anyway. Even the year you weren't giving the exam, the next year you were working on all the questions. You broke down between essays and multiple choices, so there was always something going on.
Absolutely, yes. And that's what we're hoping to do. I mean, I think that one of the impacts that we've experienced is the fact that we're moving from this advisory commission model to hiring consultants all at the same time. So time, both for our time and for finances, it had a different impact than it has in previous years. Yeah.
We're sort of shooting the blind with this.
Right.
Yeah, absolutely.
Hoping we're right.
Mm-hmm. All right.
Okay, so that's I think that takes care of it. That takes care of everything for the financial and operational key indicators. Let's see. After that, we will be going to our report on legal specialists examination and post-examination application statuses. So, and for that, we would turn to Adrian.
So this report looks at the number of applicants that successfully passed the 2017 legal specialist examination. And we're tracking those that passed, how many of them have already submitted their applications for initial certification. They had until April of this year to submit their application. However, they could have requested an extension of time up to January 31st of 21. So 71% of those successful applicants have already filed an application, and we are expecting an increase of those applications as time continues. Excuse me.
Adrian, do you know how that tracks to like years past at the same time period? Sorry.
Excuse me.
Water.
I don't know off the top of my head, but that's definitely something we can look at.
Cool.
I'll make note to have that for next.
Yeah, it'd just be interesting to know, if we're seeing the same or increase or decrease
Correct.
in
So
people follow up.
at this point, we would be 2 years out of the exam. So yeah, we can definitely look at it like 2 years out from the last.
Thank you.
Yeah. Are there any questions regarding this item? Any numbers?
No, not here.
Cool. And that's it for this item.
All right, and we'll go right back to Adrian with the approval of proposed certification revocations for failure to certify.
Yeah. So this item is looking, there's a staff recommendation to revoke the certification of applicants or specialists who have not yet applied for their recertification that were otherwise due through November 1st of this year. Notifications have been sent. They've been sent as early as 6 months prior to their expiration date. And we've sent notices even after. So staff is recommending to revoke the certificates of the 188 specialists that are provided if there's no response to a final notice. And this would be consistent with past CBLS action.
Okay, does anybody have any comments on that?
Other than I know several of these who are on the estate planning, trust, and probate law, who, still have on their email that they're specialists and the like. So I query whether I've gotten all those communications. I'm happy to reach out to some of them that I know.
Now, but within this time period, I would imagine. I mean, is there any objection or is there any comment in terms of like the procedure that we're looking to follow here that Adrian's just laid out? That if they don't respond within 30 days, that's lights out.
Sure. I guess I trust that that's what's gone on, but I mean, I look at some of these names. They are big-time specialists. They practice in the area, hold themselves out as specialists. I am shocked that they wouldn't be renewing. So I'm only querying whether they actually got communication.
That's. Does anybody else have any comments along those same lines? Is there anybody that jumps out at you here that you would be?
Well, let me ask a question. How is the communication in writing? Is it email? How are we communicating with them?
The initial reminders, the 6 month, we send reminders 6 months prior to their certification term ending. And then there's one that's 60 days prior, 30 days prior, and then a week after. Those are all automated electronic messages, notifications.
It goes to the email on file with.
I mean, Linda Kramer is a former commissioner. She's right down the road here. She's still practicing. I talk to Linda all the time, work with her firm. I'm surprised.
Well, you raise an interesting point. I mean, if you have a personal relationship, it would be great to reach out to say, did you get the reminders? How did they come?
Oh,
Maybe
I'm
they're
going
hitting
to, but
spam
I'm
filters
just-
if they're email,
I'm totally shocked.
So I think it would be good to reach out and see, because maybe they are hitting spam filters. These things happen, right? And if that's the case, we may have to look at how we're doing the communication to ensure that it's reaching the intended recipient.
We talked about this at the last meeting.
Yeah.
And I think we said that we were going to send a letter as well. And I think we did that for that last round. I'm wondering, should we do this now? So it sounds like we have a 6 month prior, a 60-day prior, a 30-day prior, and a 1 week after. Should we add a physical letter that gets mailed out in one of those stages?
Maybe I'm in the minority here, but I don't think so. I think one of the kind of basic parameters of being a certified specialist is actually kind of keeping up with whether or not you remain a certified specialist, and whether you fall into those particular timeframes. And, and as for spam filters, that happens. I would hope that most lawyers would know to have the state bar not be, state bar emails not be.
The interesting that would be, though, is it's an automated. Depending on if it's coming out of Ames now, it may not.
That's
right. So we did introduce a new technology in there. But I agree with you.
It might not recognize
State Bar notices that I've had to go retrieve out of spam, but for the fact that I happen to know that website, I just did that this morning, just right now. Went to a spam folder, a spam filter, and but for the fact I was looking for it, I would have deleted it.
However, I do agree with you that there is a certain amount of responsibility and ownership to the individual to know, theoretically they're maintaining and they're doing the education that they need to, but I do also know that we get busy and it's a fine line. So I want to at least understand how the notifications are getting and if they're reaching or not. The other and the follow-up, I wasn't going to bring it. I'll say it now, but we can talk about it later. Is how are we policing after we revoke? Right? He said, I'm sure that there's plenty out there that are still calling themselves a certified specialist. Well, I shouldn't say I'm sure.
There are.
Okay. I'm assuming that there are people that never remove it from their signature line on their email, right? We all have outdated email signature lines and whatnot. So what is the policy and how are we policing that to enforce that it's been revoked? For another point, because we have an action item that we have to take, but I just do want to throw that on there to discuss.
Right. Well, but I think it's relevant. Like before we get to the action item, I think that it in terms of how we just kind of approach this. I mean, the problem is that it kind of gets to a meta point. It's like, how do you even how do you police people practicing law without even being lawyers? In terms of like doing consultation on stuff
Wait,
like that.
that happens?
Yeah, or for that matter, like calling themselves specialists without ever having taken the exam or applied.
Correct.
Like it's. I think it's a.
I have a question about this. So, everything to this point has gone out via email, correct?
Yes.
I'm assuming this revocation notice would go out by mail?
We'll do both.
Okay, and then they have 30 days to correct it. So there is at least one mailing that's going to go out to these folks because, the recertification only comes up every 5 years. So, I mean, I couldn't tell you what year mine is due, but I keep up with the legal education, et cetera, and I'm on the commission.
Yeah, fair enough.
So I think that, making sure that folks have notice and an opportunity to cure it before they have to go through the entire exam again would be appropriate.
I agree. I think by policy, we should have at least a paper before something happens where we revoke somebody's rights. We should at least give them an opportunity in paper.
Right. I think it's fair. One letter won't kill us, I would imagine.
He's going paperless here.
I know. I'm just, I don't know. Maybe I'm just stickler. The other thing I noticed though is that there are different certification end dates here. It's one minor concern I would have is like some of these folks, the certification only terminated, say, a couple months ago, or expired a couple months ago, as opposed to others that are working on about 6 months.
We didn't look at these at the last meeting.
Huh?
We didn't look at these at the last meeting. That's why there's some that go as far back as June.
Okay.
Yeah.
Okay. So those folks already got the benefit of the doubt. Like they already got a lot of rope. But anyway, I have no.
So if I reach out to the 8 people that I happen to know here on this list, who do I have them contact if they intended to recertify?
You can give them mine.
Okay,
Please.
thanks.
Okay. So do I have a motion as to the recommendation that's on page 2?
So moved.
I have a second. Is there any objection to unanimous consent on this one? Hearing none? Okay, the record should note that Mark abstains, and otherwise there's unanimous consent outside of Mark.
Also, sorry, before we move on from that, in terms of this notion, we can't talk about it now because it has not been placed on the agenda, but policing the revocation process or suspension, do we want to agendize this later? Because we have a rule. If we wanted to develop guidelines, this is the group to do that. Should we add it to an agenda, a future agenda?
Personally, I think it's important.
I
As
would
the public
agree.
member, it's
Totally.
all about the public protection. And if
Okay.
people can go and we're not actually removing it from their ability to promote themselves as a specialist, it defeats the purpose. So
Okay, because that's something that we could control. I mean, this whole thing of people who add themselves as specialists who aren't, that would be hard to both assess and take action on. But we'll add it to the next agenda, and we can develop guidelines around that.
Great.
Okay.
Okay, so with that, we would go on now to the development of the 2020 work plan for recommendations to the Board of Trustees. And with that, we'll turn to Amy.
Okay, great. So we have some material to hand out. You will get a work plan template. We also have a copy of one that's been completed by another group. And so this is something that appears, it's an annual requirement that each of the sub-entities reporting to the board complete a work plan, like goals that they want to meet and establish. And so, as well as developing a timeline. Rather than having staff fill this out, I thought we could bring this to the committee to help and guide some of that conversation. We're also supplying the strategic goals, the State Bar's strategic goals and objectives, to use that to help us create these work plans. So there are some items in the work plan right now. There are some items in the State Bar goals that impact legal specialization. One of the things that we're going to talk about later is we're going to develop guidelines for looking at new certification areas. The more that they can align with the State Bar goals and objectives would be helpful, and that document will help you make that determination. But also, so it's a good reference tool. But also determining, like, are there goals that any CBLS member here would like to add or that we could discuss that need to be incorporated in the coming year for us. I think the ones that are in there, we talked about the, do you have an extra packet? Thank you. So we talked about the guidelines that we're developing. Sorry, let me just take a quick peek. One of the ongoing tasks by this group are the certification and recertification appeals decisions. The next item is establishing the guidelines when reviewing accreditation. That's the one that we're going to get into down the road. Also the grading. So once we're done with the grading, advancing those applications forward are some of the tasks that this group will be taking on. And the banking solution that I referred to early on is one of the items. So the question here is, I thought we could take some time, there you go, Rob, thank you. I thought we could take some time to look at the strategic plan and see if there's any additions that we'd like to make. Some of the highlights of the goals that I'd like to just discuss here is we're going to develop guidelines as how we look at new specialization areas or criteria that we use to determine whether that specialization area meets a need here in California. The issue is that there are goals here that should provide some insight to us, like, for example, Goal 1 of transitioning to the new State Bar, an agency focused on public protection, regulating the legal profession, and promoting access to justice. These have been highlighted as areas that all of our sub-entities should aspire to. And so, are there specialist areas in particular that would help us, like, for example, promote access to justice or help us promote public protection? I mean, the whole goal of legal specialization is public protection, so, how we carry that out. Are there any goals that we want to establish, or do we want to incorporate that also in our guidelines? Another goal is that might be relevant is Goal 4. And again, I'm not trying to spoon feed, I'm just trying to highlight areas in the strategic plan that might lend themselves well as value statements or guidance for establishing a part of a work plan. That Goal 4 talks about support access to legal services for low and moderate income Californians and promote policies and programs to eliminate bias and promote an inclusive environment in the legal system and for the public it serves, and strive to achieve a statewide attorney population that reflects the rich demographic of the state's population. So that's a mouthful, but I really think that there's different components. For example, are there specialization areas that there's a gap in? Is there some practice that requires that specialization would enhance that practice area? It's just one of the considerations. And lastly, the goal to proactively inform and educate all stakeholders, but particularly the public, about the State Bar's responsibilities, initiatives, and resources. We talked about one of the tasks that this group carries out, and that is, program outreach. Is there a way that we could do that better here? Are there methods that we could enhance public outreach about legal specialization? So I know that when we looked at our numbers, we're not declining. I mean, we have 60 more applicants than we did last year at this point. We have fewer resignations, but do we want to come up with more mechanisms of outreach than we're doing now as a group? So I just want to put that out there and leave it up to you guys to discuss and consider. But go ahead, Rob.
I'd like to ask, sorry. Thank you. I'd like to ask a question specifically on outreach and, framing up what the parameters are of what we can and cannot do, as a regulatory, right? Because clearly there's a lot of public education that can happen with legal specialization. Okay, as a public member prior to being involved in this body, I didn't really understand what that meant. As a matter of fact, I didn't really understand that when you passed the bar, you could practice any area of law and go out there and do it, right? So there is a lot of education that's out there, but I need help understanding what we can do as a body and what we cannot do as a body. Like, is what becomes trade association and what is regulatory and what we're allowed to do. So I need some assistance with that from staff.
And let me, I guess I can only think of responding to scenarios, and I'll tell you what we're doing now. I mean, we talked about the CAW conference that's coming up. We try to attend certain legal area or conferences and sessions in certain legal areas as outreach. We also go to the swearing-in ceremonies, because other attorneys might be there to promote legal specialization. So
those are both industry functions.
yes. Also, so aside from the legal specialization, there was one more that I didn't mention. Hold on. All right. So, sorry.
I'm more talking about straight to consumer outreach.
Yes, and then we do have those brochures that we send out so that people can use, so that actual clients, like legal clients, will know what the benefits are. So if you're going to see a specialist attorney, what difference does that make compared to a general attorney? And so we have that level of information.
Again, that's reliant on the attorney marketing the program versus the program marketing to the public.
Exactly. So
I have a question.
Oh, yeah.
In the lines of the question about what restrictions we have, what we're allowed or not, in terms of social media, do we have restrictions on that? Because, I mean, I have LinkedIn, I have the State Bar, and I get a whole lot of really good information, but I don't see anything really on legal specialization aside from maybe a little blip here and there. It would be great to have a legal specialization social media output somehow.
And maybe we could add this to our work plan, because we do have a dedicated social media person here. We do have like we have a what's the name of that? Facebook page. We have a LinkedIn page.
Right.
And so putting it up
Agreed.
there is something that definitely that we can do, especially when we want to highlight, for example, our exam outcomes. I mean, on March 13th, I believe, our results go out. And so it would be great to highlight those of like the new additions that this exam's putting forward. So yeah, that's something definitely we could.
The other, as a legal specialist, I initially, when I first became a legal specialist, and that was some time ago, but I was looking to join some sort of group to, be part of a legal specialist group where there would be legal specialist information coming out. And so that, in the lines of that as well, so also outreach to the public, but then also maybe creating some sort of a sense of belonging for the specialist to, and then also to get information out there to the legal specialists. Maybe deadlines or reminders too about, don't forget to renew your legal specialization or things like that. So.
Okay.
Thank you.
Okay. Well, I know we talked about like what they look like now, what our initiatives look like now, are this conference attendance and personal outreach that people conduct independent of us. And so it sounds like we want to expand that by looking at possibly a social media campaign and then outreach to the public. I mean, I'm thinking if we did like almost, I don't know if this would work, but an open house on anybody who's interested in what the process might look like, and having people available there to answer those questions could be one way of highlighting and promoting the program as well, based on your suggestions right now, Norma.
Well, with the commissions, sometimes we had contacts, with the bar associations, and so you had 11 different people in different counties to get stuff out, so we sort of lose that. Maybe the working groups and graders can do the same thing for you.
Okay.
One thought that I had is something that worked really well on our commission was having the commissioners do email blasts to people they knew practicing in the area who were not certified, particularly when we had like early bird discounts on taking the exam that we could send to them. And I wonder if there's a way to do emailing to the lists of the actual legal specialists with some type of promotion, encouraging them to do some outreach to individuals that they've come across in their practice area who are experienced attorneys in that practice area and can provide them just by forwarding an email with information about the specialty and the upcoming examination.
Yeah, great idea.
And I just had a couple of, in terms of this, our proposed kind of work plan, I think a couple of things that we've talked about today. One was the policing of people potentially still representing themselves as certified specialists after it's lapsed. I think that would fall pretty well under the first one, the goal 1, objective B, implement and pursue governance, operational one.
Okay.
And also something I was talking about a little earlier, just kind of like a view towards the program's long-term revenue versus expenditure kind of horizon. I think that would probably a new box, I guess.
Okay.
And that would be, I think, goal 3E, I guess, of the working the strategic plan from the bar.
Okay.
Just the financial management objectives.
Okay.
And again, I don't even think that that's necessarily like something that we have kind of an action item, for lack of a better term, on. It's just for something for us to kind of keep an eye on
Okay.
going forward in the next months.
Okay.
So, in just looking at the agenda, is the goal for today for us to actually complete our work plan and recommendations for the Board of Trustees?
Well, this is designed as a discussion session.
Adrian is nodding yes over there. Okay.
It's a discussion session. We wanted to come away with ideas that we can incorporate in here. That also, we didn't want to present a work plan that has not been vetted by this group. So the idea is to gather feedback on the current ones that are drafted in here. And it sounds like we have more to add.
Do we have a deadline for submitting?
These are due back to the board on.
These are all sub-entity work plans are scheduled to go to the Board of Trustees at their March meeting, and since we don't meet again until March, this will be the best time for the CBLS to look at it.
So I don't know, and I open this up to discussion with all of the board members here. This is a bigger task, in my opinion, than just throwing things on a page. We're defining the strategy and mission of this body in a 15-minute or 1 hour or whatever it is session. To me, it's an unreasonable expectation, in my opinion, to try to assemble this in this forum. So I don't want to speak on behalf of everybody. That's my personal.
Okay. And so if that is the case, one thing we could do is schedule a meeting, a telephone meeting perhaps, with all 7 members between now and the next group. What we'll do is incorporate what we have right now, give everybody some time to look at it, knowing that this is due in March. We could maybe schedule this either January, February, to do more development. And so
I welcome feedback. I don't want to be the only one speaking, but
I agree, especially with 3 new members, me being one of them. I would like a little bit more time to take a look at everything, and I may have some better or more ideas, I think, if we have a chance to think about it a little bit more.
okay.
And as a seasoned member, I need more time.
Yeah.
So, right.
Well, and again, this is a yearly basis, so I think the way to think about this is for the next 12 months, what work this group wants to take over. And we could consider today like an introduction to this topic. We will reschedule then something for February or March. We'll target
it has to be in February.
February. as a date. We could have a conference call. But by that point, what we'll do is we will add the suggestions that were made today into this work plan and send that out before we meet to give people time to digest and perhaps more time to have reviewed the related material to determine what a work plan would be for 2020.
Does anybody else have like things like I mentioned a couple of things that I would want added to this at the very least. Anybody else have things? I mean, obviously we'll chew on it at a later point, but like things that should be added off the top of your head, like right now.
I have a question. You had mentioned earlier to identify the specialties that would require or additional safety or protections. Can you expand on that a little bit more? You had mentioned that early on as one of the goals.
Evaluating the additional,
yeah.
you're talking about new areas of specialization? Yeah.
Was that new areas?
Yeah, it's
Oh,
new
okay,
areas.
okay,
So
all
we've
right.
received applications, and I think that when we did, people we needed guiding principles as to what criteria we should apply to new applications.
okay.
And so, part of that is starting with almost like a value statement of what this group intends to do, and we're going to discuss that later, and that is the one that's incorporated here is number 2.
Great, thank you.
And just to clarify what this is and what this isn't, because I agree that we should just probably chew on this a little bit more and like have like a chance to present this. But once this actually just gets submitted, we're not forbidden from doing things that are outside this work plan.
Not at all. If anything, we want to highlight goals that this
Okay.
group might achieve in the next year that correspond to State Bar objectives.
So I think that's important. We don't have to be worried that if we don't include it in this, like somehow we're like foreclosed for the rest of the year.
No, that's not the case.
And I understand, but I think it's important, as this is the first opportunity for us to frame it up,
Right.
that it should be pretty solid, because we've seen a lot of changes in the past
Right.
bit. So I want to make sure that they understand exactly what we think this board does.
Right, and where we're going, and maybe like some, like it would kind of implicitly give some suggestions.
The flip side of it is, I don't want things that we feel fall into this responsibility of this board to be allocated somewhere else because we didn't put it in our plan.
Right, I agree with that.
Okay. That sounds fair. So, all right, again, is the next step. We will establish a meeting date in February. We will, before that time, we will complete the work plan with suggestions that were made here today and continue this dialogue for a presentation to the board in March.
Okay, so real quick, so we're not going to vote to approve these right now. Do we need to move to actually have something take place, maybe in February or something along those lines, or will that just be scheduled
So
at a later date?
this is a discussion item, so there's no motion required.
Oh, okay. I thought this was actually like teed up to approve or not.
No, it's not. It's a discussion item, which is why we didn't incorporate the material. We just wanted to introduce the discussion. And so, but at the February meeting, if we feel like we have more comprehensive material, we could make that motion.
Okay.
We don't
Get us a
need
motion.
to formalize requesting a February meeting.
Right.
I think
No.
That's fine.
We don't.
Okay, just with that, would this be a good time for like just a quick, break before we go into a few other things? Everybody's okay with that?
Yeah.
Yes,
Yeah.
all right.
A
So
bio
could we-
break.
Could we
Does it say, yeah?
take that? Let us know. Right, just let us know when that's. All right, we're back on in open session, and our next.
Before we get to the next agenda, I've sent out, well, I've been sitting here, 7 emails to people who are on this list that I happen to know. Of those 7, I've already heard back from 2 of them. They had no idea that they were on a list to go. I'm still trying to figure out what they knew or didn't know. But, so given that 28% of this group didn't know on a small random sampling, I'm concerned about whether or not we've been effectively reaching these folks.
What did the specialists know, and when did they know it?
Exactly.
Okay, well, that's fairly persuasive anecdotal evidence. So, okay, and then the next one, like we've said, like not to go back to that, but there's going to be an actual physical letter sent out to the folks. So at least, hopefully, that's an additional layer of protection.
We can now make that 3 for 7.
3
I just got another one. So
real-time
I'm
updates.
guessing I'm going to be 7 for 7. I will bet you I'm 7 for 7 on this.
I don't know, man. I kind of want to take that bet. That seems like
7
good
for 7
odds.
is like
Let's,
7 for 7. That's pretty ambitious. Anyway, but thank you for that, Mark. All right, now we'll turn to discussion of the guidelines for reviewing applications for accreditation of specialty certification programs. And again, go back to Amy.
Okay, so this agenda item is, again, another preliminary discussion. So the idea today is to just have a discussion without voting on anything at the moment. To start looking at what the standards should be. We know what the rules are about certification, but what the standards should be when we look and when we're presented, this group itself is presented with an application for a new certification area. What should some of the criteria be? And so one of the things that was established, it looks like back in 2009, and I want us to revisit it. It looks like there was a standard for determining the creation of a new specialty. And I just thought we could revisit it because I think when I asked this last time, it sounded like people were interested in getting a guideline. And this one, we have not shared it if it was still active. And so the idea is this spells out what is required to demonstrate in order to become to submit an application. And the other items are just evaluating the potential value, substantive feasibility, degree of interest and support, and practical viability. So I thought we could visit this and see if we want to modify it in any way, given that we're just looking at some of the strategic plan goals for the State Bar. Is there any way that we want to enhance that with that new information? So I don't know if we want to stop here and just take a minute to look at this, or how should we handle this?
Right off the top, I look, and this was done and drafted in 2009 before public protection became our primary function, and it's nowhere really carried throughout in the specialization, and that's got to be what our primary function is here.
Agreed. And my question actually goes before we would actually get to this is, what is the procedure for applying? Somebody comes in, wants to create a specialty, and I see it says you need the 25 signature 25 attorneys or other such number. But how does it make it to this body that somebody wants to create a new specialty? And what is the criteria for that, if any?
We don't reject any applications, so
Okay.
anything that we've received comes here.
So somebody fills out an application, says, I believe that X should be a specialty. It comes to staff brings it here, then that's where this goes into place. I just want to understand
Exactly.
the procedure.
That's exactly
Okay.
it.
Okay, and then we would use these as the criteria for evaluating.
Yes.
Got it. Thank you.
I'd say these are pretty good. I mean, these track very well. I mean, I think some of the public protections stuff, even though it has been a relatively recent kind of like big focus change, the demonstration of the perceived need part in the required showing like really seems to kind of hit on a lot of those issues. So
Yeah.
I agree.
Well, again, so this was listed as a discussion item, so we don't have to make any conclusions at the moment. What we could do is also add this to that February agenda, so we have 2 items to discuss. People could take this and maybe, work on it, and I don't know if we want to include a value statement in here. I mean, one of the things that Mark raised is the fact that Public protection is not formally identified. However, as Roy's pointed out, it's embedded in some of the items that are appear as it's implied in some of the criteria that's already indicated on here. So my suggestion, and I just want to see what you guys think, is that everybody take a look at this and maybe we add it to the agenda for the February meeting. And at that point, maybe either enhance it with a value statement or a mission statement, and then see if there's anything else we'd like to modify.
So just, again, some clarification for me.
Sure.
Since these were already adopted by the board back in 2009, we're using this today. So, for example, I know we've talked about specialty areas. We're saying we have the 25 signatures. We've done this, we've done this, we've done this. Is this actually policy or are these recommendations?
So they're guidelines.
They're guidelines,
They're
okay.
guidelines in the sense that, we have a rule, and usually we develop guidelines that help us enhance the rule or inform the rule and operationalize it, basically. And so the one caveat to this is that they have been in place since 2009, but I don't think we've compiled them as part of our material. That's why I think we're revisiting them, because since 2009, as Mark's pointed out, there have been some changes in terms of the State Bar mission, the mission of this group. And so given all of that, I think the idea is to bring these back up, dust them off, and make any modifications that we need to so that they reflect what you, ideally, the rules and what our current operation initiatives are.
And I also think that as part of this, and I would have to think about these standards a little bit, although it comes at a second stage. It's like, a two-part analysis. One, formalizing how you actually become a new specialty area. Two, how you get it off the ground formally, because it's a chicken and egg sort of thing. It's like you have to. We typically assume we have specialists in order to evaluate specialists, but when you do a new specialty area, you almost have to have some attorneys that are essentially made specialists without having done obviously done an exam, because an exam doesn't exist. So I think maybe thinking about that as well, like how we either formalize or at least have like some kind of broad guidelines in terms of like, okay, if we do a specialty area, what do we do? Do we just do like our own market research for the most well-respected or like well-known people in this area? I mean, because it's really hard to kind of get this going without having specialists in the first place.
Well, and Roy, two things. One is that one way that we can address the chicken and the egg issue is that the next agenda item is an actual application that's come in, and so we can apply these criteria in order. We could try to determine, whether they're comprehensive or there's more that needs to be added. But also, in terms of other licensing areas, like how do you determine what the need is? You would have to know about people's current practice and also what exists. Because if you look, this application that's forthcoming is a national one. We do have national associations. Do we create a comprehensive list of all national associations and see how many of those pertain to us? That is something that we probably need to make a determination on, is how do we carry out that kind of analysis to determine what areas we want to explore. The other thing I wanted to mention and I wanted to highlight is that I just want to remind everybody, when the board was confronted with making a determination on legal specialization, on whether it is a trade association or it is a public protection effort, and that determination was made that this group serves a public protection in the admissions process for this for legal specialization, for that reason it should stay with the State Bar. One of the comments and some of the discussion that took place centered on finding specialization areas that enhance and further issues for Californians, and that includes things like the justice gap that exists, people who aren't able to access certain areas, and so like public interest law would be impacted by that. And so I just want to put that out there that that has been the sentiment. So the more that we could also address that. But it goes back to your question. How do we do that, Roy? Like, how do we look at what national trends are, what other bar jurisdictions or court systems, because there aren't that many bar jurisdictions that actually do carry this out. But how do other jurisdictions handle the, or court areas, other state courts, how do they handle legal specialization? And also looking at the national agencies as well. So just some thoughts that I would want to put out there.
So I'm going to go to a fiscal question for a second in terms of, adding a new specialty. There's obviously some sort of, fiscal hit to the state bar.
Mm-hmm.
And so, are we responsible to evaluate, the kind of P&L of adding a new specialty, or is that not in this board's responsibility and we're looking at it on merit based upon need?
If you're suggesting that we develop a criteria on the funding,
Well, I'm actually just asking the question, right? In terms of when we're trying to scope this out, like what specifically? Because there is that,
so do you want to know the fees or associated with it? Like, what is it that people have to pay in?
Should we as a board be taking into consideration a fiscal impact of adding a new specialty?
Yeah. That's what I thought you had asked. So I said, are there policy implications about the fees that should be incorporated as a criteria in here? And that's up to this group.
Okay.
Mm-hmm.
I will let him. He marks 6 for 7 now. So.
Okay.
No, I'm 6 for 6. Everyone.
I understand there's one that's not in yet, so I'm glad we didn't shake on the bet. Let's just say.
6 for 6.5.
Okay.
But anyways.
Sorry, we digress.
Yeah.
I saw him over there making a
Okay.
motion at me.
All right.
Okay, so no, thank you. That helps.
Okay. So then I want to go back to my suggestion, which was for everybody to maybe visit this independently of or outside of today's meeting. We add this to the February meeting that we'll have as a conference call on, and as a means of finding more enhancements to this, or perhaps there are no modifications required. And also, I think the part that will be beneficial is that for the other agenda item, we're asking you to reference a strategic plan, the State Bar strategic plan, and that might help inform this as well. So it seems like adding those two agenda items they correspond well with one another.
What is the rule? Because I was looking through, you guys gave us the rules. Can you tell us what rule?
Yeah, I was doing that right before I left to this meeting. This rule that corresponds with this new certification area.
I couldn't find it. I thought it was there, but then I couldn't find it when I went back through. Or just tell me the number.
Oh,
if it's in the
right.
document.
Well, it's in 3.9. There's reference in 3.90.
I don't think it's included.
But also in C, that the board may recommend the Board of Trustees approve additional areas of legal specialization and their related certification standards. So it's in 3.90C, and then you're saying it's in 3.
It's a separate chapter.
Oh, okay. Yeah, do you mind pulling it up, Adrian?
Thank you, Adrian.
Thanks.
Okay, I want to make it just a comment. It's got nothing to do with this board, so I'm going to go as an actual public member. Whoever's responsible for the State Bar's website should really go and redo the SSL certificate so the website's secure. See how it says not secure in the upper left?
That?
Oh.
Yeah, that's an SSL certificate that just needs to be renewed.
Right.
It's pretty bad.
Right. That's
So it has nothing to do with this board or my role on this board, but yeah, I don't know if you guys can raise that.
That might be the most important suggestion that comes from this meeting, actually. You know?
So there's Rule 3.902, application to certify California legal specialists. An entity applying for approval to certify California specialists must demonstrate to the satisfaction of the board and the Board of Trustees that the entity meets the requirements of these rules for approved entities and their specialty programs. B, the entity's application must be complete in accordance with instructions and submitted with the wired fee. And then 3.903 are those specific requirements.
But these are for entities. These are for already established entities. These aren't necessarily for new specializations like
Oh
California
yes, I
specializations.
apologize. These are for new or for like new organizations.
Like the IAPP.
This would tie
ones.
into the next
Yeah,
item.
yeah,
Yeah,
right.
Sorry. I'll find if there's ones for new and in general though.
Thank you.
All right.
Okay.
So any other thoughts or considerations before we move on to the next agenda item?
And just to be clear, we're gonna have this to discuss in February on a February conference call along with the our goals and.
Yes.
Okay.
Okay, great.
Okay. All right. And now we'll again staying along these same lines as Adrian was just saying, we'll go to the review of the International Association of Privacy Professionals application for accreditation as a certification program. So, Adrian, you have the floor.
Did everyone get to review that item prior to coming in?
I looked it over.
It was a lengthy packet, about 200 pages.
I have it from 2 times.
I have a.
You printed it.
I can hand it out if anyone needs a packet. Does anyone need a packet?
I actually have it from a previous meeting, so if anybody wants to look at paper, it's here. We don't have to print. It's big.
Yeah, it's pretty.
You do? Correct.
Yes.
Okay.
Yes. I did not reprint it.
Okay. I'm hoping everyone had a chance to review. Margaret Honda, I'll give her a call. She's the research manager for IPP, so she'll give a little bit of background and answer any questions you guys may have from reviewing that application.
Oh, so we're going to get her on the phone?
Yeah.
Okay.
So do we have, like looking at this, right? Required showing signature of 25 attorneys or other such number that determine recommending the creation of the specialty area. Do we have that?
This was different because it's already an organization.
Got it.
Yeah.
Okay. Sorry if you already said that.
So I have a question.
371.
So traditionally, we have not reviewed outside agencies' requests for certification or certified specialists in California other than through the state bar, correct? The actual specialties that have been developed within the state bar.
Hold on, what do you mean? Because we have. Are you talking about the state bar areas? Because we have five certifying partners currently
Okay.
that do certify California attorneys as specialists in areas that we don't directly certify under.
Which areas are those?
I don't know. I know business bankruptcy, elder law.
Yeah,
There's
National
11
Elder Law
there's 11
Association, NALA.
There's one that's related to legal mail too. It's I'll provide you the list afterwards.
Okay.
Yeah, there's definitely one that's related to legal malpractice. So, but yeah, so those are done through we call them like certifying partners. That's what IAPP is applying to be.
But I think, Nancy, to answer your question, the applications come through us.
Hi, this is Margaret.
Hey, Margaret, it's Adrian with the State Bar. How's it going? Oops. Hey, Margaret, it's Adrian with the State Bar. How's it going?
I'm sorry, I didn't hear that.
Sorry, it's Adrian with the State Bar of California. How's it going?
Are you on speaker by chance?
Yes.
We are. That's actually the best way for us to communicate with you.
Can you hear us better on this microphone?
I can hear you. I heard that a little bit. Yep.
Okay. All right, so Margaret, let me tell you why we're calling, and I think you were anticipating this call. Is this any better?
A little bit better, yeah.
Okay, so we are at a CBLS meeting right now, the California Board of Legal Specialization.
We presented the application, so there are 6 members present. We are looking at the application, we're opening this up for discussion, so we're calling you to perhaps give us a little bit of, maybe a quick overview about the application, your intent, objective, and then to open it up for questions. So I'm wondering if you could give us a quick highlight on your application, please.
Okay. So are you asking me to give an overview? I'm sorry, I am still having a hard time.
Yes, sorry. So it's an overview, and then we'll open it up for questions, and I'll help you. We'll help make sure that you get to hear those questions. So yes, if you could give us an overview right now, that would be helpful.
Okay, of the company or of why we're applying to become the specialization?
Perhaps both. This is your. You're going to sell this program to us right now.
Okay. So the International Association of Privacy Professionals is an industry association that, ultimate mission is to grow the privacy profession internationally. And we do that through a variety of ways. Obviously, we have our certification program, which is why we think we would be a great addition to the legal specialization with the State Bar of California. So we, as individuals, go through our certification programs to become specialists in different areas of privacy. And we do have this legal specialization certification that has been in existence for about a year and a half now. And then we have other parts of our business as well, such as events, and that's also how some of the lawyers who are part of our association will get their continuing education hours. Many of our events go through that process as well. And then we have just general memberships. We have people who just are members with the IAPP, and they are able to access and become better professionals through the research that we produce and through the news publications that we publish on a regular basis. And we are international, but we are focusing our legal specialization here in the United States.
All right, thank you.
Did anyone have any questions about that?
We're going to open it up to questions.
Is anyone familiar with the IAPP? I guess that would be a good question to ask.
I am not, so this is news to me. All I've seen, this is Mark Lester. I'm one of the members of the board. I've read through the application and its supporting documents, so this is new to me.
Okay, all right. So that's helpful for me to know in terms of baseline. But as you hopefully have seen through the application, we do have a pretty established program focused on legal specialization. And we have a number of our members who currently are certification holders in that space. And what we're trying to do is expand our reach in terms of having the legal privacy specialization recognized for those states that don't have the ABA recognition, of course, California being one of them. So that's the reason behind us going through this application process.
Okay, and this, hi, my name's Aurelio Torre. I'm also a member of the board. I just had a question specifically in terms of the certification requirements. Rob and I were talking about this a little bit. The practice requirements. You pass the exam. You have continuing education requirements, but I think the wording was ongoing and substantial participation over the last 3 years, including at least 25% of the person's practice. Is that correct?
At least 25% of. Say that again. Again, I'm having just a little bit of hard time hearing everybody. I'm sorry to say.
I'm sorry. I'll try to be a little clearer. So the requirement for certification is that it has to be that the privacy practice has to be at least 25% of the person's professional practice.
Yes. That's right, to qualify, right, to take the certification. That's correct.
Okay, and then the evaluation of ongoing and substantial participation for an applicant, like, is that just, I mean, that can take a lot of, a lot of different forms, I would imagine?
The ongoing participation,
Yeah.
it could take the form of what again?
No, I'm just, like, what different types, because that's the thing, like, because one of my concerns might be if somebody is practicing, can a lawyer be certified in this, in this particular area and be practicing in non-legal aspects of privacy practice?
Oh, yeah, and other aspects of law, for sure, yeah.
Oh no, but for instance, the privacy practice thing, I don't know if I'm being clear. The privacy practice element, the ongoing and substantial participation that a lawyer would show to get this certification could potentially be in non-legal aspects of privacy practice?
So I just want to interrupt to say that I've been joined with my colleague, Bridget Meringue, who really is down and knows exactly all about this process of how our members go through the certification process and how they prove the things that you're asking about. And so you're asking basically how would they prove that 25% time? I'm just stating back the question so that we can answer it correctly.
That's part of my question, definitely.
Okay. So I may ask Bridget to weigh in here because she might have the right answer. So Bridget,
yeah,
go ahead.
Absolutely. Applicants is that they, provide, a personal statement, of basically like a resume of what they've been doing in their ongoing work in that. And then we also professional recommendations that follow their overall, the overall experience in privacy law. And one of those would be what they're doing now. And that's the corroboration we look for in providing that proof. Does that help?
Well, yes, sort of. I mean, what I was getting at is that this, because we would be certifying you folks as a partner entity for the legal specialization, and what I'm not necessarily concerned about, I just want to be clear on, is that the folks that we would be giving reciprocity to in terms of these certifications would be practicing in privacy law as opposed to kind of general like privacy practice.
Yes, the certification is law specific.
Okay.
It would have practice, and we've had that, we've come across that question throughout the process as well. As you know, every one of our applications is reviewed by a board, and that's one thing that came up because there's the distinction between actually practicing law, just consulting, where does that line fall? Are they from an operational standpoint? And we've come to the conclusion, at least for now, that because it is by the American Association, it is a privacy law specialist, it would be for privacy law only.
Oh, okay. Okay, I just wanted to clarify, because obviously you can be a member of the IAPP without being a lawyer. But yeah, I just wanted to make sure that this was specific to privacy law. No, so I thank you. That helps.
Yeah, this is something different. Yep.
Could you tell us a little bit about the two examinations that required? What are they made up of, and how long are they to take?
How long are they at the end of that? Can you repeat the end of the question?
Yes, could you tell us a little bit about the examinations that you administer? What's the makeup of them in terms of types of questions? How long do they take to administer the exam?
Yeah, sure. So both the CIPM and the CIPP-US exams, which are the two certifications that are required for the specialization, are both 90 questions each. Takers are for exam, and all of these questions themselves are multiple choice with some scenario sets within them. So a scenario will be given, and then there will be around, between 3 and 6 multiple choice questions relating back to the scenario. And those 2 of our certifications are 2 of our ANSI accredited certifications. So those are the 2 required. And the third exam, and this is depending on in the bar in which the applicant is practicing law. And we also, so the third one is an ethics exam. And that one is 15 questions. They are given an hour to complete. In that.
So is there any essay component at all in the examination process?
No, not in the exam process. It's all multiple. In the application process itself, you do require personal statement, which in length is similar to an essay administered and reviewed by the board upon application. So it is a requirement of this specialty, but it's not required to exam.
Were you able to get that, Nancy? Did that answer your question? Yes. Okay, good. I thought we had to repeat.
And then what is the designation that we would be giving these people who've passed your legal specialist?
It would be the PLS, the Privacy Law Specialist designation, which is the specialty we received for by ADA.
And then is that made up of the parts of this CIPM and what is it, CIPT certification?
You guys, I'm having a really hard time.
I can't, yeah.
Not only hearing, but understanding. It's I don't know how helpful this is when it's considering the quality of what we're getting.
Regrettably, it's the battle of the hands-free.
I'm wondering if we call them on actually a telephone and just put it up next to, or just trying to do the speakerphone over the loudspeaker.
Are they there?
Margaret, are you still there?
I think it kind of became academic. Could be why we can't hear them.
I'm just gonna end this one for now.
So can we have some discussion? I mean, they could have been on the phone or not, but so that if you're not familiar with this, so this is all in the cybersecurity space, right? So IAPP, there's something called ISACA. There's a number of different bodies out there that issue different certifications for people in the security specialty, right? So IAPP's CIPP is what they call theirs, right? Certified Information Privacy Professional. ISACA has one called CISA, C-I-S-A, which is, I'm a member of it, so in full transparency, part of my consulting in the past has been in cybersecurity. So I am a member of ISACA, but I mean, it's not relevant because I don't hold any of their certifications. But their CISA is Certified Information Systems Auditor, and then they've got a Certified in Risk and Information Systems Control. So ISACA, a similar type of organization, doesn't have any legal, they don't have any legal certifications, but it is a primarily cybersecurity and information security body. And they have a program where lawyers, and what I'd like to get them, what I was going to ask is, you know, it sounds like that you have to be an attorney, and then you also have to pass their, and I just forget the name, CIPT,
right? Right. That's what I was trying to ferret out.
I want to pull up these requirements.
So those are the requirements. So there's legal requirements in their website. By the way, I'm on their website now, which is their PLS, Privacy Law Specialist. Okay, so the application requirements is be an attorney admitted in good standing in at least one U.S. state, earn or hold a CIPP U.S. designation from IAPP, so that's the privacy, plus either CIPM or CIPT. So they have 3 different designations, and I can take us through that. Pass the ethics exam administered by IAPP, or submit a recent MPRE score of 80 plus. Provide proof of ongoing and substantial, and that's bold and in, you know what, maybe we just bring it up here. Bold and in quotes, involvement practicing privacy law, at least 25% of your full-time practice over the last 3 years. It's just iapp.org/PLS.
And by the way, that's what I was like slightly concerned about, because what privacy law means versus security consulting is something that I don't know exactly what. I mean, this could. I don't know if we have like lawyers that also happen to consult on like a lot of like kind of just general cybersecurity issues, and they consider that practicing privacy law, which really. Right,
which is not legal, it's more technical.
Right, and that's the thing. That's the thing that I, what I was trying to get at.
So they sell, not like that, like you're not buying the certification, but they sell packages to apply and take an examination for certification in privacy. That's the way I understand the organization. I could be wrong. That's what I wanted to ask them. So this is already something that they offer, but in order to be part of the legal program, you have to have previously passed 2 of their certifications, 2 of their other certifications, and be an attorney. That's the way I understand it. So, as opposed to a legal organization that's looking to add a specialty on.
Right.
And,
$28.95.
And so much?
East Coast, I don't know where I'm East Coast.
Okay.
Oh, I was reading about it. They're located in Portsmouth, New Hampshire.
Right. Lovely.
So, again, I'm not making any judgment calls on what I'm telling you. I'm just telling you what I think it is and what I understand it to be, right? And what I'm reading online. So, 5 peer references from attorneys, clients, or judges attesting to your privacy law qualifications.
That's some kind of barrier to entry, at least.
Well, but this is more for the state bar. For our purposes, since this is a national organization, do we require that they have 5 peer references from California attorneys and or clients and judges, or do we accept from out of state? Because that becomes now, how do you vet that? We just talked about how we vet our own internal state.
So for our CTC organizations, they're the ones that enforce and track their specific requirements. What they do is with their annual renewals, they let us know if there are any substantive changes to what they've already provided to us.
So again, I'm asking for out of ignorance and clarity. So I'm an attorney in California. I qualify for their program. I get 5 peer references, but none of them are from California because that's not a requirement of theirs. I still, if we approve this, can call myself a certified specialist in the state of California in privacy law.
If IAPP approves them, yeah.
And then do we as the state bar, this is the certifying organization, so if an attorney comes and says, I want to be a certified specialist in privacy law, we say go to IAPP?
Exactly.
Okay. That being said, and again, maybe I should abstain because I am familiar with ISACA and I'm a member of it, there are a lot of these out there. And I'm in no position to say that these guys are better than those guys, or the third party that I don't know about is better, but there's much more work I think that needs to be done before we just say, okay, they're the first to market, we're going to join on.
It seems, it just strikes me as this is a very broad privacy organization that has tacked on an attorney component where, and like, look, I haven't seen any of these applications, I don't know, but that basically if you're an attorney and you practice in this area and you've already been certified by them, and the standards are very vague, 25% of your practice, ongoing and substantial. What is privacy law versus privacy consulting? What is cybersecurity consulting versus actual legal work? that sort of thing. Yeah, I have concerns.
This area, by the way, obviously in business is humongous. Ransomware, I know many companies in small Santa Clarita that have paid their ransoms to get their data back because they've been crypto locked or whatnot. So this is a huge area, and I think that we need to really, I know I'm not on, sorry. This is a huge area of business. Was I loud enough anyway? Were you picking it up? A huge area that if we're gonna go into this, I think that, and I don't know the right procedure, we need to evaluate maybe multiple different agencies. And again, I'm not in that business anymore. When I was doing my consulting business, I'm now head of marketing for a different company. But there are a lot of these associations out there.
So I have a question. I'm not familiar, but I'm going to ask you about it. In terms of the protection of the public and making these, certifying these folks as legal specialists, I would think that as California State Bar, we would need to have California state requirements and protections so that we, as a board, can oversee that. Who are their clients generally, and is there a need for that public?
So these are privacy professionals. I can only speak for ISACA, but I've been reading what they are. It's pretty much the same. It's people that are working in information security, right? So it's beyond just the computer security, cybersecurity, but it's disaster recovery. It's everything having to do with information security and data at a company. So it could be an individual that wants certification. That if you want to do governmental contracts, you want to do DoD work, for example, you have to hold certain certifications, and then you take those certifications to the DoD, and then there's additional things that they require of you. So they get kind of certified, like they're coming to here, by the DoD to be able to do that. So it's security individuals. Now they may be in-house, right? So it could be the head of IT for a company, or it could be what they call CISO, Chief Information Security Officer for a company, and they have different designations and certifications. This is one body, is my understanding, that does those certifications.
So jumping on Norma's comment, I just wonder if this is an area of law that we need to consider for specialization in California. If our goal is to protect the consumer of legal services.
Right.
And the legal services that a privacy law or cyber lawyer would be giving would be primarily to government entities and large corporations or medium.
California has one of the most restrictive security. It's just about to be enacted. It was passed by the legislature. It goes into effect in January. You probably heard of GDPR, which was in the EU. It was their global general data protection regulation, right? And basically said if you do any business with anybody that is an EU citizen, no matter where they reside in the world, you're governed by it. And it protected the kind of data that you could actually store, cookies, those types of things. It's very, very restrictive, and there will be a lot of lawsuits that individual consumers can bring against it. California's is almost as restrictive as that, so I agree with you.
And I don't think that, it may be at some point in the future that you see a lot of individuals who are subjected to potential liability for these issues, but at this point, I don't think there really is that. We haven't come to that point yet where individuals have these issues and would be seeking lawyers necessarily.
It could be on the flip side. It could be that the individual, that the public, is suing somebody for violating their privacy with remarketing of data, with those types of things like Facebook and whatnot. So I think that it wouldn't be necessarily representing the corporations, but the individuals.
Yeah, and I think that one of the things that at the very least, because I think we should defer this application to March. I think that we should, because there's a lot of questions now that we're talking about. But in particular, I think that hits it on the head, that I think we've been comfortable with national certifying organizations to the extent that they are in areas where either the federal practice is the be all end all, or
the general area of law, the things that they're teaching and looking at are very, are easily transferable to California. Here, we could theoretically have multiple people that are not practicing in any of these specific aspects of California law to be certified as California special. I would be very uncomfortable.
And in their application, they are upfront that they only have 6 to 8 members in California at this point. So it's not like there's an overwhelming cry from the legal community that this certification needs to be, identified.
Right. I agree. It's a California thing. To your point, I'm just looking at it here. I agree.
And I don't know that we could consider a specialty area like this that is, the largest consumers of the legal services are businesses and government entities, when, for example, we have not given a specialty to employment law for the same reason. And that's an area where there's a great need in California.
And so I think, and I don't know, I'm just getting a kind of the general sense of the room. I think this should be deferred to March with some of these specific questions. But one of the questions that I don't know if they could answer specifically how California specific law is incorporated, to what extent it is, if it is or it isn't, and then the extent it is to what, like how much of this is tested, how much of these different, because for all we know, maybe like California companies are so ubiquitous in this kind of area that the national organizations are already testing for that. I mean, like that could be something that we could also keep in mind when we're evaluating.
California it has the most comprehensive. Just when I looked, and other states are starting to follow, but we definitely have the most. I shouldn't say definitely. We have one of the most comprehensive. California Privacy Act is a new one that goes into effect. So I think it's a great point. I think we should have California standards because our standards are higher than everybody else's.
And the clarity of how much of this is law related and how much is simply technological related.
Correct.
We need that definition.
Yeah, and I definitely
that's
am
unclear in that area.
Right. Well, but that's the thing. Theoretically, like, look, you could pass. Like, let's say you pass the bar. Like, you pass the bar. Like, you may theoretically be able to get certified by these folks like right away. Somebody with your background.
I just have to pass the bar anywhere.
Right. And so, but okay. So in terms of asking for more information, I just want to get this sense so that Adrian can take it down. First, the extent to which that California specific law is California specific experience and or knowledge of the law is needed with respect to the exam.
And it's called CCPA, California. I'll look it up. But CCPA is California's law.
And two, and that's what Mark was getting at, what I was talking about before, is that the extent to which, while there is like privacy law experience and privacy law practice has to be of at least 25% of your professional practice, to what extent is that specifically legal versus in terms of dealing with legal requirements for different things versus could it be kind of general kind of like privacy and cybersecurity sort of things that kind of leak into that are meeting legal requirements, but really it's just more a question of kind of technical sort of compliance and technical know-how. So those are two different. Anybody else would have any specific?
Yeah, just following up on what I had. My main concern right now and what I see is the perceived need, the section that we have here, and the public protection, and what's the need of, is it difficult for consumers to identify these experts? And I'm just reading off of this, consumers may be particularly vulnerable and sophisticated. Are those components in there in terms of privacy on the need to specialize, to certify legal specialists with regard to that, the public protection?
And just also the consumers that use this service, who use these lawyers, who are, they have a breakdown of lawyers who practice in this area. Who are their clients?
Right.
What's the makeup of them?
Right. And because I think that goes definitely to the consumer protection purpose. If we're dealing with more corporate entities that frankly are going to be a little more sophisticated, vis-a-vis how they can vet the legal market, that there may not be
the burning kind of public protection interest that there would be in, say, family law or something where, like the public, like, have general members of the public have more contact with that area. So, anybody else with questions that we would want to present before the March meeting to IAPP?
And are we saying, kind of to that, are we going to save this for March or February?
I think save it for March. I mean, my idea was that these questions would be presented to, is it Margaret Honda? The concerns we have will be presented to IAPP from your end, presented to them. They would have responded in some form. We could look at that response and then we could evaluate from there. I mean, because I think that in general we definitely get the sense we're not ready to like approve this as a room.
Maybe related to Natalie's questions to Margaret earlier. I was just looking at the rules. The rule here, they have to have a written examination.
Yeah.
Which they said they did not.
No, they said they have, the examination is written, but it's all multiple
It's all
choice
multiple choice.
as opposed to essay.
And they have to include California law in their exam.
So but I would be still very. I think it's a very pertinent question. Like to the extent California law, for all we know, like maybe California law is like 50% of it, 75%. We maybe like they've we're asking a question that they already have a very ready-made sort of answer for.
I mean, they definitely got us thinking and raised a lot of questions, which is great, No, but seriously, but I am in a complete agreement that we represent California, and our laws are different than other states. So.
Well, as part of their package, you do see their multiple choice questions. So if you dig deep in there, and they seem to be very general as opposed to California specific.
And with that, do we have any more things that we want to have Adrian frantically type out as we discuss them? Any more questions? Okay, so I guess the decision is to defer this until March. We're going to get input from the IAPP as to these specific questions, and we will go from there. All right, and with that, I believe that brings us to the end of open session. We will, unless anybody has anything else to add, we'll close out the open session, and we'll stop the recording from there. And after that,
one thing I'd like to see put on the agenda, and probably this is the
one thing I'd like to see put on the agenda for March. As I understand that they are revising the state bar examination for attorneys in general to the point where they are considering taking family law and wills and trusts out of the examination areas, which is going to make specialization all that much more important. And so we want to be, I think, looking at that exam and what the impact on specialization is, and is our program adequately addressing the public protection with those areas now being taken out.
Oh, which exam?
The state bar, the regular new admittees.
I think you're probably talking about CAPA, which is the California Attorney Practice Analysis, and those are kind of some of the things under consideration, with regard to the topics on the exam, which ones should be, which ones shouldn't be. I think these are just recommendations that are going to be made. And anything that's going to be done won't be for at least 2 years after the date that notice is, and the exam would have to be redesigned. So we're talking about a pretty long process, but that was something that was discussed in terms of, the possibility if we take a subject off, whether or not that might be able to be addressed in terms of concerns for public protection in some other vehicle, including possibly legal specialization.
Well, if we can be in coordination with that, so if they're doing those things, specialization has been about consumer protection, and so I think we ought to be included in that discussion if we could be.
already done.
Yeah, I think it's all the more reason for us to like kind of cut it off at the pass in terms of like, you know, if this is gonna be, and if certain areas that we specialize in that are gonna be taken essentially away from the presumed knowledge area of practitioners, I mean, I think that's definitely that's a definite concern. Thanks. All right, so with that, we'd close out the open session. And